Hello, and welcome to the Noble Law's Top 10 Things to Look For in a Physician's Contract live webinar. In this webinar, employment attorney Katie Abernethy will be outlining the common elements of a healthcare professional's employment contract, including what to advocate for and what to negotiate out of the agreement. If you're joining us after the fact on YouTube, feel free to subscribe if you are interested in seeing more videos about employment law and how it affects your workplace. Katie joined the Noble Law with over 15 years in the defense bar at large international law firms. As a defense attorney, she defended claims arising under Title VII, the Age Discrimination Employment Act, and ERISA, among other employment-related statutes. She also has extensive experience litigating claims for breach of contract, unjust enrichment, and defamation, among other causes of action that frequently arise in employment law matters. Without further ado, let's dive into the top 10 things to look for in a physician's contract.
So first things first, when you've got your new contract and you open it up and you take a look at it, the first thing you're going to want to look at is how long is this contract for? What's its duration? I can tell you from having looked at, hundreds of physician contracts that on average, if you're a North Carolina physician, you can expect that they're going to give you a contract for an initial period of somewhere in the ballpark of 2 to 3 years. It can be as low as 1 year, but I would say 2 to 3 is more the norm. And usually there will be some sort of provision very early in the contract that will tell you how to renew that contract. So at the end of 3 years, if everything is going swimmingly with your employer, how do you renew that contract or how do you renegotiate it at that point? You need to be very wary of contracts that require both parties to renegotiate and sign a new agreement at the end of the initial term. So for example, if what your contract says is that at the end of 3 years, the parties will negotiate in good faith to try to arrive at a new contract, that's something that you need to know and pay very close attention to. In general, I would say physicians are usually better off with an automatic contract renewal. In other words, the language will say that at the end of the initial term, whether it's 2 or 3 years, that the contract will automatically renew in 1 year increments or 2 year increments thereafter, unless it's terminated earlier using the termination provisions of the contract. The reason I say physicians are usually better off with automatic contract renewals is that y'all are busy and you tend to get busy and at the end of 3 years, maybe not remember that it's time to renegotiate your contract. And unfortunately, hospitals and healthcare systems are not truly infallible about this either. And so they may forget that at the end of 2 to 3 years, it's time for you to renegotiate your contract. And what happens then if you just keep working and then let's say at the end of year 4, suddenly you want to leave that employer or the employer decides to make changes to your practice area and they decide they no longer need you. Well, when you go back to look at what your rights are under your contract, a lot of times what the employer is going to say is, we don't have a contract anymore. We didn't negotiate a new one when the old one expired. So you're just an at-will employee, which is not where you want to be in the state of North Carolina. So you are always better off trying to get an automatic contract renewal provision negotiated so that if everybody gets busy and forgets, you still have a contract. The other thing that when you first open up your contract and take a look at it, the other thing that you'll want to make note of very quickly is whether they are designating you as an employee or as an independent contractor. And you need to be very, very wary of any contract that designates you as an independent contractor rather than an employee. An independent contractor is supposed to be a person who's in business for themselves. Think about like a consultant or something of that nature, who's not dependent on that particular employer for all of their income. So basically the whole idea is if you've ever worked with a CPA to get your taxes done, your CPA is an independent contractor. They don't work for you full-time throughout the year. They come in once a year and do your taxes, and they do 1,000 other people's taxes as well, and you pay them, but that's that. An independent contractor designation gives you a lot fewer rights and legal protections. So for example, independent contractors are not entitled to the protection of certain federal statutes that are basically anti-discrimination statutes, such as Title VII, the Americans with Disabilities Act, the Age Discrimination and Employment Act. It also means that you're not entitled to the protection of state laws like the North Carolina Wage and Hour Act. There are also circumstances where as an independent contractor, you may not qualify for the benefit of certain whistleblower statute anti-retaliation provisions. So it is always in your best interests to be an employee and not an independent contractor. I do want to briefly take on a myth that I've heard a lot of physicians kind of bat around, which is that being an independent contractor gives them certain tax benefits. Oh, your tax benefits are better if you're doing work under a 1099 as opposed to a W-2. First of all, from what I've seen from working with prior clients, those tax benefits are pretty minimal. And they certainly do not offset the fact that by becoming an independent contractor, you're waiving employee benefits. You don't get paid time off, you don't get disability insurance, you don't get health insurance. So if you weigh the tax savings you're getting against the employee benefits you're giving up, certainly an employment arrangement is more to your benefit. Unless you are a practice owner who is operating their own clinic or their own external practice where you have a lot of employees and you have a lot of equipment expenses, your tax benefits are not substantial enough to make it worth your while to be an independent contractor usually. So just be aware of how you're classified, because it does have a significant impact on your rights and your legal protections. One of the next things that you'll often see in physician contracts after looking at your classification and what the term of the contract is that it's going to explain to you what your job duties are. And in the course of doing that, the contract is probably going to also tell you what is or is not permissible in terms of outside activities. I would say that here in North Carolina, contracts with major healthcare systems are likely to be split. You see about a 50-50 split between allowing and prohibiting moonlighting. Particularly people who've been doing residency or fellowship, sometimes are used to maybe moonlighting for a hospital. You really need to check your contract to make sure that you're going to be able to keep doing that if in fact that's what you want to do. Some hospital systems will prohibit you from that and will want you to agree that they are the only employer for which you're going to work. You also want to look for provisions that talk about whether or not you get to keep things like honorariums for speaking engagements or academic engagements. If you do expert witness work, say in medical malpractice cases or in personal injury cases, do the fees for that go to the employer or do they go to you? Generally speaking, I usually advise my clients that that's, particularly if they've got a lot of outside activities, that's a pretty easy place to negotiate with an employer, to just allow them to allow the physician to retain the money that they earn through the activities that are sort of outside of their usual scope of professional responsibilities. However, you may run into a situation as well where the hospital system will try to place a restriction on the number of hours or the amount of money you earn as a result of your outside activities. So if you plan on engaging in some moonlighting or in doing some paid speaking engagements or some expert witness testimony, be sure that you are checking your contract to make sure that whatever those limits are match your intentions for how much outside work you plan to do. And pay particularly close attention to the language of clauses in your agreement that require you to remit to the employer all compensation received. That's where a lot of hospital systems will get people who engage in outside activities. That clause, if you're engaged in outside activities, should be pretty narrowly written to require that you remit only that compensation earned by performing services for the practice's patients. In other words, it's only your patient care services for which they have the right to bill and collect, and for you to remit any money you receive. It is not for your outside activities, such as, speaking, doing academic engagements, etc. So the next section that you're likely to see in a physician contract is where they finally tell you what you really wanted to know all along, which is what they're willing to pay you. So your salary and bonuses. I don't think it's any secret among physicians that salary tends to be pretty dependent on your specialty and your type of practice. So while salary is pretty straightforward, I think that where physicians often get into trouble, and where I've had to represent a number of physicians in disputes with their employer, is with respect to bonuses or incentive compensation. So be very concerned if you open up your contract and it says you're entitled to, something, let's say a salary of $200,000 a year, and you say to yourself, for my specialty and practice area, that's a little low. And they say, oh, don't worry about it. We're going to make that up to you in your bonus and incentive calculation. And when you look for that, it's actually on an exhibit to your contract. And it's a mathematical formula that goes on for like 4 pages. And it starts talking about the numerator of which is X and the denominator of which is Y. That's a bad contract for you. Let me tell you why. Your practice is never going to do those calculations correctly. And I cannot tell you the number of disputes that I've been involved in where that kind of a convoluted bonus calculation was put into a physician's contract, and later on nobody, and I mean nobody, seems to know how the calculation is actually supposed to get done and what the inputs are. So the more complicated the bonus calculation, the more likely that the practice is going to miscalculate that and underpay you. So if a significant part of your compensation is going to be dependent on your productivity or revenue or something else that they want to, pay you on a bonus or incentive basis on the basis of, what do you do about that? Well, there's a couple of things. One, always push for a simpler formula, a straight percentage or a straight, and be sure that you're working with your employer to identify exactly what the revenue category is that your compensation is going to be based on. So is it total revenues for patients that you see? Is it going to be total revenues for the practice? Is it going to be, is it going to be your net profitability? What is the number that they're going to start with to figure out how productive you are, or how much you've earned? The simpler that calculation is, the better off you are. The second thing you want to make sure to try and negotiate is that if you are dependent on some calculation that starts with, your monthly billings for seeing patients, that the contract requires them to give you a standardized report, no less than quarterly and preferably monthly, from which you can look at the numbers that they have for you, and if necessary, you can readily calculate exactly what you're owed. If you get them to include that provision, the first thing you want to do in say it's usually about the 3rd or 4th month of your employment. They'll do it for the first month, they probably will do it for the second month. About month 3 or 4, that's usually when employers suddenly just forget one month to give you your spreadsheet. Well, you have to follow up and require compliance with that. You have to tell them that you're not going to waive or ignore the fact that you're supposed to get this report that's going to allow you to double check to make sure you've been paid correctly. A problem that I've sometimes had with physicians is that, the practice complied for a couple of months and then didn't comply for 2 years. Well, when you go back to the practice then and say, hey, we want all of these reports for the last 2 years, they say, well, it seems to me your client's kind of waived his right to that because he hasn't, he's never asked for those before. It's not a good argument, but just save yourself the inconvenience and follow up and require compliance and save those reports somewhere. I don't know that you need to save them for more than a couple of years at a time, but keep them handy because you may need them if there is a dispute about whether or not you've been paid appropriately. And I included this slide mostly for people who are coming off of their residency or their fellowship. A lot of times you'll see in contracts for brand new physicians that there's usually some kind of loan agreement. A lot of times they'll offer that, or hospital systems will offer that in lieu of a bigger signing bonus. They'll offer to give you a loan so that you can pay off, say, relocation expenses or something of that nature. It's pretty common, and there are traps for the unwary in that loan arrangement. So first of all, the time period that you have to work to obtain complete loan forgiveness is pretty important. Because I assure you that if you do not work that entire time period to obtain that complete loan forgiveness, you will receive a bill from the hospital or the healthcare system at the end of your employment for whatever remains unpaid. So the initial contract term shouldn't be any shorter than the period needed to complete the loan forgiveness. So if their time period for loan forgiveness is 3 years and you've only got a 2-year contract, that's a problem. That leaves you hanging for a year. The terms of any ability of the employer to accelerate payment of the loan need to be spelled out, and the interest rate and when and how interest accrues on that loan needs to be spelled out and explained. Generally speaking, if you're a physician, you'll want to negotiate for the shortest possible forgiveness period you can get whenever and wherever that is possible. So just a few tips to kind of keep in mind if you're a newer physician and your employer is offering you some sort of loan. So this number 6 is the first clause that if you ever have to retain a lawyer, it's one of the first clauses I'll look at. That's the termination clause. This clause gets invoked when somebody gets unhappy. The typical termination clause in the state of North Carolina usually allows either party to terminate the contract without cause, for any reason whatsoever, for their own convenience, by giving anywhere from 90 to 150 days of prior notice. How long that notice period is going to be usually depends on your specialty and how difficult it is in the particular geography for a hospital to replace you. So if they're going to have a lot of time, they're going to have to spend a lot of time recruiting somebody to come move to, outer Egypt to take over or to take your place, you can expect to see a longer contract notice period in there. The typical clause will give the employer the option of waiving the requirement that you work during the notice period and instead just paying you your salary for the notice period without further work obligation. So let's say you decide you're going to quit your current position, you give them 90 days notice. Most termination provisions say that the hospital can call you and say, hey, saw you dropped your notice. We don't really need you. We've got all the shifts covered. And, to be honest, we don't really want you back on site. So why don't we just pay you for your 90 days and we'll go our separate ways? And so that is a pretty typical clause, and it's actually a fairly physician-friendly one, because even if you're kind of on the outs with an employer, they still have to pay you some amount of time. Gives you a chance to start thinking about your next move without having to worry quite so much about the financial end of that. Now, that's what I've just described is what's typically described in the contract as termination other than for cause, or no fault termination not for cause. There's always also a for cause termination provision in physician contracts, and that termination for cause provision is going to allow the employer to terminate their contract with you immediately and without any further pay under some very specific circumstances. One of the most important things to negotiate in any contract is the definition of what constitutes for cause. And that definition should be very concrete, and there shouldn't be a lot of wiggle room about what does or does not constitute a for cause termination. Be wary of any ambiguous words that are used to define what constitutes termination for cause, and to the best extent you can, you want to negotiate to eliminate any form of employer discretion from that determination. So I've provided in this slide some examples of some typically legitimate reasons that you'll see in termination for cause provisions. And then I've also identified some kinds of language that you'll see that you want to negotiate out if you can. So typical legitimate reasons include things like criminal conviction of the physician, loss or suspension of your medical license, loss or suspension of Medicare or Medicaid billing privileges, permanent disability of the physician, you become uninsurable for professional liability, loss of hospital privileges, or willful refusal to comply with practice policies. Those are pretty typical reasons that you'll see in a for clause termination provision. The reasons that you want to negotiate out, and these are just some examples, you do want to carefully parse the contract and think about how much discretion does my employer have here to decide whether this is for cause or not for cause. But things to try and negotiate out is you'll see for cause provisions that say, that they can terminate you for cause if you failed to provide job performance satisfactory to the employer. Well, what does that mean? It means that any little nitpicky thing they decide they want to seize on so that they don't have to give you notice and don't have to pay you suddenly becomes a basis to terminate you for cause. The physician's failure to meet patient volume or revenue metrics, that's kind of ties back to what I talked about earlier. If those metrics, if the opacity of how they're calculating those metrics is a problem, then you can expect that you could have a problem with them playing with the numbers on patient volume or revenue metrics so that they don't have to give you notice and don't have to pay you. The other reason to negotiate out, that you'll see this one a lot too, is that the physician is determined to be disruptive in the opinion of the employer. The whole idea of a physician being disruptive is one that gets abused a lot by hospital systems. And what they'll do is anytime somebody, say for example, is a whistleblower or points out to administration that something that they're doing is illegal, unethical, unprofessional, immoral, they will determine that making such complaints makes you disruptive. And you don't think it can happen, but I see it in my practice all the time. So you want to make sure that they don't get to just determine willy-nilly that you're disruptive. If they want something in there about you being found as a disruptive physician, that should be a finding that should come from some sort of hospital peer review committee, not in the sole discretion of the employer. We decided that we think you're disruptive. let's talk for a minute about some areas where the employer can either maybe beef up the offer a little bit or get a little cheap with you, and that's surrounding malpractice insurance, CME coverage, and license renewals. You know, I'd say on balance, most of the physician contracts that I review require the employer to pay for or reimburse the physician for costs of malpractice insurance, that require the employer to pick up reasonable CME expenses and license renewals. It's a good thing to negotiate for, just to get a little, you know, particularly if you don't think that the employer is going to be willing to pay you a lot more in salary or whatever. Try to negotiate for reimbursement of costs of professional associations and certifications. And most importantly, do not forget to negotiate for the employer to bear the costs of your tail coverage for professional liability on your departure from the practice. You wouldn't believe some of the tail insurance coverage quotes that I've heard from some of my clients over the years. They can be pretty significant, and you don't want to be caught holding the bag for that. You don't want to be caught having to write a check for that because you didn't negotiate into your contract that they have to purchase that tail insurance. So let's talk for a second about non-compete clauses, because those have become very, very common in physician contracts. I would say it's the rare physician contract that doesn't have a non-compete clause. Non-compete clauses should be specific both in duration and geographic limitations. And wherever possible, you want to negotiate the shortest duration and the smallest geographic limitation on your ability to compete after you leave your employer. On average, I'd say physician non-competes tend to be about 6 months to a year in length. Any more than that is pretty unwarranted unless they're making a significant investment in setting up a practice for you. So for example, if they're purchasing a lot of equipment or they're building some kind of new facility for your practice, or they're hiring a bunch of new personnel for your practice, maybe then there's a reason to go beyond, 6 months to a year. But generally speaking, 6 months to a year is more than sufficient time. One wrinkle that is very specific to physicians is that the non-compete needs to contemplate compliance with the North Carolina Medical Board's guidance about notifying patients of a departing physician. As I'm sure you're all aware, the North Carolina Medical Board has some rules and some standards about patient abandonment. And as a result of those patient abandonment rules, it's got some guidance and some rules about what you need to do to notify your patients if you are departing from a practice, because you can't just abandon the patients. Usually, and what the North Carolina Medical Board wants is they want you to send a joint letter that comes from both you and the practice, goes out to each patient that you normally treat with, and inform them that they have a choice of following you as the practitioner or staying with the practice. That's what the North Carolina Medical Board expects will go out in that letter. Now, when you look at your non-compete, what it's going to say in the first draft usually is that the employer is going to want you to agree that once you leave, you're not going to do anything to invite or solicit any of your current patients to follow you to your next practice. And you may have to pull the North Carolina Medical Board's guidance on patient notification and provide that to the employer that you're negotiating with, so that they know this isn't just you trying to get around your non-compete. This is actual North Carolina Medical Board guidance that everyone has to follow to make sure no patient is abandoned. So just kind of be wary of that when you're looking at your non-compete clause, and make sure that that's something that you're discussing with your potential employer beforehand. I've included a slide here about assignment of inventions and protection of patent rights, mostly because it is something that comes up for me here in my practice in the middle of Research Triangle Park, North Carolina. There are a lot of physicians that are involved in, once again, outside ventures, technology, medical technology ventures, or, in developing new therapies or developing new medical devices. And for those individuals, it's really important to take a close look at the assignment of inventions and protection of patent rights clauses in the in their contract, and they're always in there. I have yet to see a physician contract that doesn't talk about this. So a lot of times the language and the length of the paragraphs for this are enough to numb you and put you to sleep. But it's probably in there, and if if you're involved in medical research or in development of new therapies or medical devices, you need to watch out for this. So most of those clauses are going to say that you have to assign to the employer any patents for innovations that you've invented during the period of your employment. So basically, they're going to take the position that anything you invented while you were employed with them, whether you did it on their premises during your working hours or whether you did it on your own at home or did it as part of some outside activity that you were engaged in, they're going to do a land grab and take the position that they own all of that. And they don't necessarily. You should absolutely negotiate for a narrower clause that says, that they are only assigned any patents for innovations you invent, during the course of your regular job duties, in the course of your employment for them. Expanding it to anything you do during the period of your employment is a little overreaching there. Even if you're in a type of job where the development or new or innovative products or treatments is part of your regular job duties. So let's say you're a physician who's going into a pharmaceutical company or into some kind of research science role, you should still negotiate for inventor status on patent applications submitted from, based on your inventions, and a percentage of the royalties that the employer receives for all of those inventions. Now, your percentage of royalties is going to be expressed in, 100th of a percentage. I'll just warn you. But you do want to make sure that you're getting credit and getting, some sort of revenue sharing for new or innovative products or treatments that you are part of developing. And it pays to remember the default rule. Here in North Carolina, if you go to court and there's a dispute about whether or not you own a patent or whether your employer does, the default rule is that any invention created by the physician during the course and within the scope of his or her employment are considered works for hire and are therefore the property of the employer. If you have circumstances that make this general default rule problematic or unfair, you need to make sure to have appropriate language included in your agreement to protect your rights to your inventions. Finally, and this is the last of the 10 types of contract provisions that we'll go over this evening, you want to take a close look at your dispute resolution provisions. And I know that that doesn't sound like a really glamorous thing to take a look at the time you're negotiating a contract with a potential employer. But if for some reason you and the employer do get into a dispute, how is that going to be resolved? A lot of hospital systems have started including arbitration clauses in their standard physician contracts. You want to think about the pros and cons of arbitrations before you sign that. Now, a lot of times for the bigger hospital systems, you're really not going to have a choice because they're not going to hire anybody who won't agree to their arbitration clause. But if you're working for a mid-size or smaller healthcare system or hospital or practice, they may be more willing to negotiate with you a little on this. So the pros of arbitration. It's not all bad. I mean, the pros of arbitration are it's a private proceeding, so you don't have to worry about your name getting dragged through the mud publicly. And I have to say that in my experience, arbitration usually moves faster than litigation. Arbitrators tend to push the parties a little harder to get through discovery, to get through dispositive motions, and to just get to a hearing and get it all over with. The cons or the downsides of arbitration is that there's usually limited discovery, which hurts you in a dispute with your employer, because chances are they've got all the documents and you don't. There's no right to a jury trial, so your dispute is going to be decided by a single person known as the arbitrator. And then the other big con of arbitration is it is a lot more expensive than litigation. I mean, it's a private dispute resolution process, and somebody's going to have to pay the fees for that arbitrator, because you're not using judges who are paid for by public tax dollars. So know the pros and cons of arbitration and think about those before you sign. If there is a choice of law and choice of forum clause in your contract, take a look at that and make sure that you're not required to litigate in a distant or inconvenient forum. So for example, if you are working for say a health system that or a management company that staffs hospitals all over the country, and they're headquartered out of California, you may have a choice of law and choice of forum clause that requires you to travel to San Francisco to arbitrate. These are not, I wouldn't say that they're routine. I think most arbitration clauses require you to arbitrate near the place that you work. But I have seen some in physician contracts where they require you to litigate, someplace on the West Coast. And if that's the case, you want to see if you can get that location changed to someplace a little closer to home. But you also want to be sure to note whether there's a fee shifting clause in the contract that allows a prevailing party to recover attorney's fees and costs from the non-prevailing party. And one of the most unfair things that I see sometimes in physician contracts is that it will be non-mutual. I'll look at a contract that's been proposed to a physician client, and the employer will have drafted the fee shifting clause to say that if there's a dispute between the party and the employer prevails, the employer gets to recover its attorney's fees and costs from the physician. But it doesn't say anything. It doesn't give the physician any right to get his attorney's fees and costs if he or she is the one that prevails in the case. So at a bare minimum, you want to make sure that any fee shifting clause you have is mutual. In other words, it allows whoever prevails to recover fees and costs, not just the employer. It has been my pleasure to talk to you all about this tonight. I hope that the information was useful and helpful for those who are attending or watching this later. Of course, if you need follow-up advice, or if you're looking for an attorney to review your contract for you, you should absolutely reach out to us here at the Noble Law Firm. We're always happy to take a look at contracts for new physician clients. So I hope that everyone has a great evening, and thank you so much for attending.